funky tune. You're right, Peter. Very funky tune. We've actually started a bit late. Our time isn't quite the same as my Apple Watch. I don't know what happened there. How are you, Karen?
Yeah, I'm well.
How are the kids in lockdown? There's silence in the background. I can hear that.
You know, they're doing their reading very quietly. You know, they've done. I was just showing, look, all these worksheets are done, and I'm playing teacher today. Most of her homeschooling under control. Anyway.
Well, I've got Terry very quiet in the background. He's been featuring in LinkedIn recently, but he decided to turn up to this as well.
Oh, good.
Right, well, look, we've got a lot on today, so we might just jump into it, I think. 2 or 3 things have happened. We've had a couple of really interesting cases that have come through. We've got the new psychological risk code that's come out in New South Wales on the 26th of May, which we'll talk about as well. And I think we're going to deal with this really difficult issue of out of work behaviour again. So let's just jump into it and start with the case, the Victorian full court Supreme Court case of Tucker. Tucker is probably one of the most important cases for people doing investigations. It's law which is good in Victoria and good throughout Australia. Mr. Tucker was a senior solicitor of the State Revenue Office. He did, or is alleged to have done, 2 things. One, harassed a female worker about becoming a friend on Facebook, and secondly, looked into files which weren't relevant for the work that he was meant to be undertaking. Only in respect to the second matter was his employment terminated when it was found through an investigative process that there was no proper basis for him reviewing this private information. He was a litigious creature. He took the matter to a number of different levels in trial, eventually to the full Court of Appeal. And to an extent, he was partially successful on one very, very important issue. And the key facts of that issue are this: the SRO, the State Revenue Authority, didn't make an inquiry in respect of the people's files he looked into. They commenced an investigation without those persons' permission. That's an issue that Mr. Tucker raised as a real issue because he said nobody made a complaint, and we'll come to that issue. And secondly, an external investigator was appointed, but only provided the actual findings, didn't provide the nature of the evidence and how that evidence was analysed to make those findings. And Mr. Tucker took a position that prevented him from being given procedural fairness. Now, that's all in a backdrop of a highly prescriptive policy that required a higher level of detail than would normally be required, okay? And that's a really important issue, and I'm saying it now because I want everyone to stop creating policies around investigations that create a rod for your own back. What the full court said is this: a person, for procedural fairness purposes, must be able to understand how a finding is made against them. It's not relevant who the person is, who that witness is, unless it's a key to the person raises alibi evidence. I was away that weekend with John. Well, if you haven't spoken to John and John's not identified, then his name needs to be identified that he was spoken to. And there can be proper safety reasons or privacy reasons not to identify a witness. That's fine, but you must be able to identify with clarity what is the evidence against you and how that was analysed. And Karen, I mean, you do this really well in the investigative work you do, but it sort of goes without saying, doesn't it, that you've got to let the person know how a finding was made.
Yeah, you do. Otherwise they can't respond to it. If they don't get the opportunity to respond what's being alleged to, then that's really an incomplete investigation. You can't arrive at findings that are sound.
No, and that, you know, so often people want to curate findings and just say, look, on one page we have found the following as substantiated, and the person goes, well, how did you get there? And they go, it doesn't matter, we didn't. We trust and rely on this investigator. And I just want to say to you, don't, you know, people out there who do investigations, be cautious about how you shape and state that evidence. And as I said, privacy and things can allow you, and safety, a number of things can say, well, you don't have to say what the name of the witness is, and you commonly have to say, who said that? And you say, well, actually, that's not the issue. This is the evidence I collected. This is what I say the evidence is, and this is how I form the view based on that evidence. That's enough for you to have procedural fairness. But Tucker will be applied repeatedly now in investigative matters. So 2 lessons from that. One is, please say what is the evidence you rely on, how you get there. That's a critical part. Secondly, please stop having crazy policies that define how an investigation is to be undertaken to tie the hands of the investigator behind their back when they go into battle. So don't do that. So that's Tucker's case. Really interesting start. The psychological risk code that's come out in New South Wales, I said, is very important for a couple of very obvious reasons, and one not so obvious reason that Karen and I were chatting before we came on about. In New South Wales, it's LAW law. In other words, if you don't comply with this code, it will be evidence that you have failed to comply with what is reasonably practical under the model legislation there. So very simple. The code is fantastic for employers and very dangerous for employers in the same way, because it does look at what is the evidence behind psychological stress. And of course, what we know about the evidence behind psychological stress is, yes, bullying and workplace violence are major reasons of causing psychological stress, absolutely. But the major causes of psychological stress are lack of job definition, overloading of work, all the types of implied or quiet factors. So I'm just having a look there from Marie. So my understanding, investigation is determined by OHS standards and any accreditation. I'll come back to you on that, Marie. The issue here comes to the heart of, well, what are the hazards in the workplace that cause risk? And they are the way you delegate work for people to be done. And in these remote environments, it's incredible risk, isn't it? Because work is being shifted in not only a virtual way, but in a tacit way as we try to get things done because we're not sitting around each other. Karen, you and I have spoken, I think now for the last 6 months, about the importance of actually identifying roles very clearly, one, and second, assessing the nature of risk that sits around the delivery of workplace capabilities so we know that it's not hazardous. And this code goes to that issue.
Yeah, it does. We're at risk of sounding a bit like a broken record now, Andrew. But yes, we have said this before, and the great thing about the code is that it provides very clear definitions, and certainly as a minimum standard in terms of what should be done. So for, I guess, employers who have been proactive and put in some controls and a framework to manage this, that's fantastic. So, but for those who have kind of not at this moment prioritized that, certainly this is a really important moment, because it's very clear that there is the expectation, I guess, a claim to ignorance, that's just not available anymore, is it, Andrew, in terms of what we don't know what it means?
It's certainly law in New South Wales, but in every other jurisdiction, it is evidence that a court can rely upon of what is reasonably practical. And one of the key parts of this code, as it says, as you're undertaking that assessment of risk, you must take into consideration the personal circumstances of the individual. And again, I know I am a broken record on this. When you do a risk assessment about someone's personal well-being, the person is part of the risk assessment process, as are their broader circumstances which they live. So look, interesting, fascinating. Nina's done a great article that's online on that. So please, and thanks, Nina, for that. And also for the update, Nina, that you've done on restrictions and the government rollout of the $500. So it's all up. Now, Matt has helped us out with the case of Shockman. I don't even know where to start with Shockman's case, because I know the moment I do it, you're going to start laughing. But the short answer is Mr. Shockman worked at Daydream Island. He notified his employer and they were aware of 2 conditions he had. One was narcolepsy and the other was cataplexy. Both of them are sleep-based disorders, and they both have the potential for fatality or serious illness. So they knew what this hazard was. Mr. Hewitt shared a room with him. Mr. Hewitt, after going out in a drunken rampage at night, came in and, for reasons we'll never understand, decided to urinate into the mouth of Mr. Shockman. There it is, I got it out without grinning. What that did, though, is set him into a cataleptic attack, which caused him serious health damage. He brought a personal injuries claim, and the personal injury claim failed in the Queensland Supreme Court. And what I want to say about this is, this does show us that in the Supreme and federal courts who don't practice in safety, a complete lack of knowledge of safety law. Okay, because what they said is there's definitely a duty to provide a safe place for Mr. Shockman to live and to work, because they provided this accommodation. The accommodation was part of the employment.
We're serious, Jeanette.
Yeah, no, serious. Yeah, no, it is serious. And then they found that there was no actual connection with the employment. Now, that's where you should be saying, Jeanette, oh my God, are you serious? Because in employment law, so many cases, and probably the best known case is applicant V versus the employer, where an organisation placed an employer in a hotel, not to work, they stayed overnight at that hotel. No work was being done at that hotel. The guy had a drink and then squeezed a waitress's bum and sexually harassed her, and they terminated. And he said, well, that wasn't work-related, how can you do that? And they went back to the old case of Rose and Telstra and said, where you do something that is incompatible with your employment, as an employee, we're entitled to terminate you even though it wasn't at work. And there was a very recent case, which we've talked about before, which was an Aboriginal cooperative where a young man trained young Aboriginal men, and that was his job, around domestic violence, and then beat up his wife and was locked up overnight on it. And the Aboriginal organisation terminated his employment because they said, well, how can you ever come back to teach? And the court said, yeah, no, you're absolutely right. By doing what you did, you so damaged that relationship. Here is a case where a man does something. How could he ever work with Mr. Shockman again? So the answer is, this is some really bad law that's come out by the Supreme Court of Queensland. It's dumb law. It's not the way the law would be determined if it ever made its way up to the High Court. It breaches safety principles about how you measure duties. And quite clearly, as an employee, Mr. Hewitt would be terminated without difficulty. And they did have an obligation to provide a safe place. Karen, you talked about if this was a child, if you look through that lens, this was your child.
Yeah, I did. When I read this last night, I mean, aside from on the outset, you're thinking, oh, Jesus, this is really terrible, in terms of what's going on here, in part almost comical if you're really at arm's length. But if you look at it, you know what, if I frame this from these were two kids, right? And there was two kids in a room, one child where has two serious medical conditions that are on your premises under your management, and if this happened, you'd be absolutely appalled, and you think, well, hang on a minute, with this knowledge, we have to do something about that. Now, a policy in place, which would be helpful in terms of setting out what the expectations and standards of behaviour and what you should and shouldn't do, that's a good starting point. But you actually need to have controls in place in terms of, well, how do we minimise the risk? What things do we need to do differently to make sure that this doesn't happen, or at least reduce the likelihood of it happening?
Yeah, can I just say you're on the money, because you got the hazard, haven't you? You know what the level of risk is. The risk is really high, and there is no controls. And all the court said is, look, there was no policy. I mean, give me a break. The lack of the policy is one of the missing controls. It is the thing that actually demonstrates the breach of negligence, because you've got a duty of care, you've got a standard that applies, and there's been damage. There's not remoteness. They're on that island because they're employed. There's no remoteness around. Anyway, look, crazy case. I just wanted to say, in employment law, there is a connection. In safety law, absolutely.
Yeah.
If you look at the Port Hedland case about the dongers that got blown away in the terrible winds, Kerwin's case, and all of those cases say there is a connection, and there is also in negligence law. Anyway, that's enough of that, me bagging the Queensland Supreme Court. What we were going to talk about today, because of Tucker, was investigations and what you can and can't do. And just starting off, when we're dealing with an investigation, your finding is based on the standard of proof that comes through from Brigginshaw case, which says, yes, it's a balance of probabilities, but the more serious the nature of the allegation, the better the quality of the evidence has to be. Okay, that's the standard in Brigginshaw. So if I say Karen stole something, I can't do that on the basis of gossip. I've actually got to go and look at the records, demonstrate Karen was the only person who had access to it. I've got to be able to do that, okay? The next question comes, and why I try and discourage you on a regular basis from doing investigations under legal professional privilege, unless there is some higher reason, there's organisational risk that you want to capture, is because legal professional privilege is very easily waived. Now, legal professional privilege arises where the dominant purpose of doing an investigation is to provide advice to a client. It's not to create findings, okay? Because that's an investigative role. Do you see the difference? One is I'm advising the client about a risk. Second one is I'm doing findings. So if all an investigator does for you is create findings, and you as a lawyer then just transmit the findings, there's no privilege that attaches to it. And it gets worse. And this is one of the risks that Karen and I regularly talk about, is unless you're insured, what is the reason you would create a written statement? Because you will be cross-examined on that statement when the matter goes to trial. And that statement forms part of privilege. And the moment you cross-examine on the statement, you waive the privilege and everything comes into evidence. Now, you'll notice when we do investigations for you, unless it's a criminal thing where we do have to create statements around it, and then we won't put privilege over it, we don't use statements. And that's the reason we don't use statements, because the moment they will be cross-examined upon, and the moment they are cross-examined upon, you waive privilege. And secondly, of course, when you're making a statement with somebody, they get a chance to continue to finesse and fillet their statement to put the best version of it, whereas what they tell Karen on the first time is most likely to be the best answer they give. So there are a whole series of cases like Bowker and Kirkland that all come around that, the DP World cases, which say, if you've got a privileged report and it has findings within it, in respect of a person, you have to disclose those findings to that person, that part of that report to them. So legal professional privilege is a real risk. Okay, used cleverly. For instance, I've got higher level management risk. We provide the findings without privilege, but we provide advice that sits above that, which doesn't form part of the report. That's the way it should be used. But I come back to Tucker's case, Karen, today, which talked about when you have this competing evidence and it's not laid clear what is the evidence and how you form a view on it. As a person who does really difficult and complex investigations, how do you deal with competing evidence?
Well, there's a couple of ways. It depends, Andrew. So firstly, sometimes, well, it could be because the employee's a little bit, they don't know whether they have to be wholly honest, or they're unsure in terms of how much they should say. I think in those instances, firstly, it's a matter of educating and reinforcing what employees' obligations are to act on, take reasonable instruction and direction. And certainly that includes complying with company policies and procedures.
And their duty of fidelity to always act honestly.
Yes, common law obligation.
Yep.
Secondly, it could also be a matter of presenting the evidence in such a way that it makes it easier for them to respond to. So that means that, for example, if the open question isn't working very well, and you might present the evidence in such a way that on a particular day it's been said, or this particular statement was made at this time and by this person, when you present it that way, it makes it easier for the person to speak to.
So can I just say, as a matter of law, Karen, the important part is that you can't rely on an allegation unless the person can respond to that allegation. So if it's saying, look, Karen, you're always rude to people, well, you actually can't respond to that. Yeah. You can only say that on this day at this time you did.
You said these things were. Yeah. It's been alleged that you've said these particular things. Then it's much easier because, well, no, I didn't, or I didn't mean it like that. And suddenly, you've got a response, okay, that you can capture. Now, where an employee is also being elusive or evasive, be encouraged to challenge and encourage them. So, for example, if they're saying, look, I don't quite remember that, or I'm not quite sure. If you built that rapport correctly with them from the start, then goes, look, that doesn't sound quite right. So you can dig a bit deeper and challenge people, but that needs to be done really tactfully, which goes to my last point around using really skilled investigators as well. So if you're skilled, you will be able to build a positive rapport quickly. Now, that's not to say you're getting super friendly and being mates, but certainly in terms of building that trust quickly, to be able to obtain the information correctly and accurately. So they're my thoughts.
Yeah, and look, the police now don't hit people with phone books. Well, they're not meant to anyway, but they've invested a whole lot in training their investigators on neuropsychological skills of connection and engagement, because they find they get better quality evidence when they connect to people. That's not being their mate, it's listening, it's showing they're listening, but it's also allowing you to challenge in a way which is not cross-examination. And can I say, in a civil jurisdiction, which is Fair Work Commission, when we're dealing with terminations, investigators who cross-examine are looked upon very badly. So you're right about that subtlety around how do I challenge. It's not, I put to you that such and such happened. That's really bad behaviour. Well, that's just not believable. That's not good behaviour. But you can say, look, please be aware this is the heart of the allegation against you. So I want you to think really carefully about it. The evidence I have is this, this and this. For you, it's really important that you do respond and give me your best shot at it so that I can understand it. So what you're doing is saying to people, look, this is why it's important. This is what the evidence is. This goes back to Tucker, that people can see what the evidence is. So that when you come to explain what your findings are as an investigator, it takes the respondent, doesn't take the respondent by surprise when you say, this is the evidence that I was presented with, this is what the respondent said. On the basis of these three people and the respondent not being able to provide me with a proper recollection of offence, I make this finding.
Mm-hmm.
So the other part in the wet investigation is it doesn't start, there's not two parts of it, the investigation and the report. The report should look like the investigation. It should have the same thematic process, the same generosity, the same clarity, and the same objectivity. You should never be seen as prosecuting a theme as an investigator.
Absolutely. And Andrew, in terms of the investigation work we've done previously, you know that I've got a very clear, logical framework that makes it very easy to present that information as it is in terms of what the issue is, the facts, the rules, and therefore, based on all that, what the finding is.
There isn't anything you do that isn't clear and logical, Karen. I just want you to know that. Even the kids in homeschooling say to me, my mother is clear and logical. All right, well, let's go on to the problem, Safe. Could you bring up our problem for the week? Here we go. All right, now this is only one page. I'm hoping it's only one page, so I try to write it for one page. Diane was distressed by what Gavin said. They're obviously employees. It was a sexualized comment about her low-cut dress and breasts. Gavin was known to make such comments, but the women in his area were scared of him. Danny, Diane and Gavin's manager, saw Diane crying and asked her what was wrong. She explained what happened. Diane said, please stop him, but don't use me. Danny asked HR to investigate Gavin's conduct. Isn't this so common? Something bad happens, but please don't get me involved. Dave from HR constructed a list of complaints going back 2 years from various employees, put them to Gavin, who denied them, and Dave subsequently found them all substantiated. His findings were brief, not identifying the evidence of the witnesses, just the misconduct. Gavin was dismissed. Okay, they are the facts for today. Short, succinct. Let's hit the poll. Now, we've got a lot of people here today, Karen, so we'll have to give them a bit of a chance. Now, can I just say to you, the questions I'm offering you today are not easy questions. So there's no easy questions in today. They're all complex. So if you're not feeling sure, don't be surprised. Let's give it another 30 seconds, Karen, because we've got a lot of people.
Sure.
Your kids are being fantastic. That's very quiet. Very, very quiet today.
Who? Me?
Yeah.
Well, yeah, they're quiet upstairs, but I can hear birds outside. I'm thinking, oh, I can't win, can I?
Yeah, well, I've got Terry sitting here waiting for one of the lockdown deliveries to come so he can squeal down the stairs howling all the way. So.
Oh, gosh.
All right,
another 5 seconds to go.
5 seconds to go. We should have a delivery anytime now with a piece of clothing that won't fit and have to be sent back.
Okay, anyway, I'm ending the polling.
Okay, I'm sorry. Okay, well, we're locked in. So let's have a look at what our results are.
Mm-hmm.
Gavin argues he's not provided with procedural fairness in the termination of the process as he was denied the opportunity to know the evidence. Is he right? I think from Tucker's case, he's right. Okay. Mm-hmm. I think doesn't mean you have to know every piece of evidence. Does that make sense? But you do have to know the quality of the evidence that you're against and how that frames up against you. Gavin also says, in any event, no one made a formal complaint and there was no proper basis to undertake the investigation. Is he right? This is a tough question because your procedure will probably require a complaint to be made. And if that's the case, you've just excluded the occupational health and safety discrimination employment legislation. Mm. And you can do that by policy. Isn't that dumb? So remember, under safety law, if a hazard arises, you have an obligation to determine, is there a hazard? What is the risk? That's an investigation. Yeah. Any form of employment law like anti-bullying legislation, the moment you're aware of that type of risk, you must engaged. So your policy should always provide you with an uplift process to be able to investigate without a complaint, and also have privacy elements in there which allow people to be safe within the raising of a complaint, not to be identified in certain circumstances. The other part, Karen and I would commonly, where we have someone make a fleeting remark, like they feel unsafe, someone treats me badly, there's other ways around it besides investigations if you're not sure of the character or calibre of the evidence you're getting, and that might be by running a pulse survey in that area to tell you whether it's there. So there's other ways around, but the answer here is not clear. Okay, I don't think there is a correct answer because we don't know what the policy or the process is. What we do know is without a policy, we would be able to investigate. There's no problems with that at all. Okay, because the law requires you to undertake that investigation. 3, the incident with Diane happened at Friday Drinks, informally arranged by Danny outside of work, immediately after work finished on a Friday. Can action be taken against Gavin since it was outside of work? Okay, this is the Rose and Telstra issue. The first part is it's not outside of work. So that's the trick part of this question. Because Danny is the manager, organises it and supports it, it is like a Christmas function. Therefore, it is a work function. Therefore, safety procedures apply and all policies and procedures apply. And therefore, it was a trick question. I was being naughty. Okay. So
not really, Andrew, because people think this is a getter. You know, they'll get around it in terms of, well, look, well, work won't put on drinks, but we can do something instead, and I'll take you out and we can just have a couple of drinks together at the end of the week. He goes, well, you got to rethink that in terms of what that actually means and the risks that sit around that.
Yeah, there isn't the nasty Kernahan and Leighton Holdings is a nasty case which puts you at risk in this, because what that says is, well, you condone the drinking and the behaviour that was occurring. Therefore, you can't punish the person who behaved badly. But if anyone put in a workers' comp claim or a discrimination claim, they would be successful, but you can't terminate somebody's. That's one of the binds about drink-related functions. Okay, that's why I, like a broken record, tell you that if you have a work-related function, then the policies and procedures of the organisation apply, and the people who are senior are supervisors and therefore must comply with the law. That doesn't mean you can't have fun. It does mean that you have to have a process. Okay, what's our next question? I'll just open up my slides so I can see my next question. My next question is, the incident with Diane happened at Friday Drinks. No, I've done that one. So the next question is, Gavin says the old complaints, pre-Diane's complaint, were all things Danny knew and did nothing about. Does this condemnation mean no action can be taken? And again, our answers are all over the place, and so they should be. So the law of the doctrine of condemnation is that you can't punish what you've permitted. Now, the Fair Work Commission looks at it slightly differently than the pure doctrine, because what it says is it depends on how bad the behaviour is as to whether condemnation applies. So Karen is doing some work for me and I'm angry and I say, that's just rubbish. What do you mean? Bad behaviour, okay? But nobody does, and my boss doesn't say anything about that. And I say that a few times to Karen. It offends her, it hurts her, she doesn't like it. And then one day I start screaming abuse and threatening her. Well, my past condemnation is relevant evidence towards the last part, okay? So all of them can be examined. The difficulty here is that most of the behaviour has been condoned. Everyone knew about it and did nothing. And therefore it's old, been condoned, and I think you'd have a lot of trouble with it. So I think the big issue here is it would be evidence that's relevant to his most recent egregious behaviour, and that behaviour would be enough to have him moving towards termination of employment. But can I raise with you again this process that when someone breaches your values, your code of conduct, you must act upon it. Otherwise, you end up in this really difficult grey situation, and these women are feeling unsafe and damaged. Right, now we're towards the end of it. So what I want to do next week is really dig down again with you on investigations, because there's been a whole set of questions that have come back. So what I'd like to do is answer those questions in clarity next week. I'd like to get Karen more involved in the investigative process so you can see how her mind works, because she does it so well. And that should clear for you. And we want you to be doing your investigations as much as you can, okay? So that's what we're going to do next week. Thank you very much for attending, and we'll come back and answer any questions that arise. See you later, guys. Bye-bye.
Bye, everyone.